Alrighty, that number's slowly going up still, but in the interest of keeping things going, we'll get a move on, and everyone that jumps in later can come in. So, welcome everybody to another Employment Essentials Masterclass by Employment Hero, where we break down complicated entitlements and obligations under the Fair Work Act into more easily digestible information. My name's Georgia, and I am a team leader here within the advisory team at Employment Hero.
Hi, I'm Rishi, and I'm a HR advisor at Employment Hero.
Thanks for that, Rishi. Just before we jump in, some housekeeping to start. We have allocated some time at the end of the webinar for your questions. Please just type your question into the box at the bottom using the Q&A function. We'll have Candace from the advisory team as well answering some questions that do come through. For those we do not get to, we will endeavour to answer after the webinar, but if not, we will have a Q&A sheet that gets sent out after as well for every participant today. Um, Today's session is also being recorded, and that recording will also be made available after the webinar has been concluded. If the webinar inspires you to access some further HR support, we will have some contact details at the end for you to get in touch with our team. And finally, we do touch on the general process for managing disciplinary processes. However, these matters can become quite complicated in certain circumstances, and not all scenarios will be straightforward. Sometimes it will be the case that you may need to seek independent legal advice. Now, off into our first topic for today, which is, I guess, a little intro into workplace misconduct and kind of understanding what that actually means. So, when we talk about misconduct in the workplace, it's something that almost every employer will face at one point or another, and how it's managed can have a significant impact on both the individual employee and the wider organization. Misconduct doesn't just relate to obvious cases of wrongdoing. It can range from minor breaches of company policy to the more serious, issues that pop up that can threaten the safety, integrity, and reputation of the business. Throughout today's session, we're going to explore how to identify different types of misconduct, how to respond appropriately in each scenario, and what the best practice steps employers can take to minimize risk and maintain healthy, compliant workplace culture. So let's start by unpacking what these definitions really mean in practice. Starting with what are the definitions under the Fair Work framework? So misconduct, it's not defined under the Fair Work Act, but it generally refers to unacceptable behaviour or conduct that breaches company policies or standards, and that again isn't defined in the Fair Work Act. So misconduct, you're looking at things like lateness, employees like using their phone at work if they're not that there's a policy that says they're not allowed to, employees not following, sick procedures such as like, calling in or whatever it might be. So their misconduct relates to the business, I guess, policies and procedures. Serious misconduct, on the other hand, it is defined in the Fair Work regulations, and it states that serious misconduct includes, or defined as, willful and deliberate behaviour that causes a serious and imminent risk to the health and safety of another person or to the reputation, viability, or profitability of the employer's business, or engaging in theft, fraud, or assaults, intoxicated at work, or if you have an employee that is refusing to follow a lawful and reasonable direction. As mentioned before, this conduct is involving that behavior that's so severe that it will destroy the trust and the confidence essential to the employment relationship. This is the type of conduct that might justify summary dismissal, which means that termination without notice. However, a fair process will still need to be followed if there is an instance of serious misconduct. So, for an example, you've got an employee that has stolen company property, might have stolen money from the till, maybe has falsified some records, and you have clear evidence to support, that this has actually happened. Um, from time to time, we'll get clients that will call up and we'll be like, I've had someone steal from me. I've got evidence. I want to terminate them right now in a meeting. Um, we always advise our clients that although you may have that strong evidence to support you, especially if the employee has access to, make a claim against the business, we will need to still follow a procedural fair process. So, still following a disciplinary process, still inviting them, still allowing them to, respond to the allegations, making sure they can bring a support person, going through all that. Um, and that in contrast to, your gross misconduct, your general misconduct, with your things like, your breaches of minor policy, your lateness, your using your phone, things like that, those issues can typically be managed through informal discussions or formal meetings. It's really, really important that we understand the distinction here and we don't label something as serious misconduct unless it meets the definition outlined in that regulation, or unless it is that behaviour that would be viewed objectively as fundamentally damaging to the employment relationship, particularly in those unfair dismissal cases. Um, Great. Now we'll move into more of, I guess, why it really matters, looking at the impacts, the different type of impacts that it can have on the business. Um, it matters from obviously a compliance perspective and overall health of a successful business. We often find that employers only start to focus on misconduct when a serious issue arises, but understanding its broader impact can help the business be quite proactive, not just reactive. And these areas that we're going to look at are the risks. The cultural response to misconduct is really, really crucial that you are in compliance with the Fair Work Act to avoid any of those claims, as I mentioned previously. Um, so even if the employee's behaviour was unacceptable and they did engage in serious misconduct, the Fair Work Commission will always look at how that decision was made, whether there was an investigation, was the employee giving that chance to respond, and was the decision fair in the circumstance. A lack of that process can mean the dismissal is deemed harsh, unjust, or unreasonable. And Rishi will chat into why that's important later on the webinar. We've also got that general protections claim as well that Rishi will jump into if they allege that the disciplinary action was taken because they exercised a workplace right. For example, the employees raised a complaint about safety and then they were issued a warning for something that's, completely irrelevant or something that doesn't require a formal warning. There's risk there in terms of a general protections claim. Now, looking at those cultural impacts, the way that an organization handles misconduct, it does send a powerful message to its people. If that inappropriate behavior goes unchecked, it can quickly undermine trust, lower morale, and lead to a culture where employees might feel unsafe or undervalued in the workplace. Um, Contrast to that, if you are a, proactive business owner and you're dealing with those issues as they pop up, you're dealing with them fairly and consistently, it builds that confidence in leadership. It reinforces those company values and supports a respectful and accountable workplace. It's also important to remember culture is often shaped by what leaders tolerate just as much as what they promote. Ignoring misconduct can silently normalize it, while that consistent action shows employees that standards are equal to everyone and they apply to everyone, no matter, if you're just a junior or if you're in an upper management position. And then we're looking at the operational impacts as well. So these can, have a real impact on productivity, team cohesion, how you're delivering, whatever it is that you're providing, can impact your clients, which obviously can impact you financially as well. It can create that friction between team members, turnover costs, reputational damage if it spills outside of the business and it's not kind of controlled and contained. But if it is managed early, it can actually strengthen the business operations, improving that accountability, communication, and overall performance. So it's not just a requirement from compliance, I guess a compliance and risk standpoint. It's a business critical process that does, shape that culture, maintain that compliance, and drives that operational success.
Now, understanding the legal framework. Managing misconduct isn't just about correcting poor behavior. It's about understanding the broader legal and operational responsibilities that come with being an employer. Under the Fair Work Act, employers have a legal obligation to provide a safe and healthy work environment. That includes taking reasonable steps to prevent and respond to misconduct, particularly when it impacts others in the workplace. Operationally, if misconduct is not addressed, it can lead to a range of issues: increased absenteeism, declining morale, loss of productivity, and higher staff turnover as well. In more serious cases, employers may also face legal action from employees who feel unsafe or unsupported. For example, if an employee is being bullied or harassed and the employer fails to act, the employee may seek a stop bullying order from the Fair Work Commission under the Act. If that order is breached, it can result in significant penalties for individuals and the business alike. To manage these risks, one of the most important legal principles employers must understand and implement is procedural fairness. Procedural fairness is a cornerstone of lawful and ethical misconduct management in Australia. From a Fair Work perspective, it ensures that employees are treated fairly and transparently when issues are raised. So, what does this look like in practice? First, employers must be given clear notice of the allegations, including specific details of what conduct is in question. Second, they must be given an opportunity to respond, to share their side of the story and provide an evidence in their defense. The process should be handled by an impartial decision maker with no personal interest in the outcome. Employees must also have access to relevant information and are generally entitled to bring a support person to any formal disciplinary meetings. Finally, employers should clearly communicate the outcome, including the reasons for any decision made. Now, why does procedural fairness matter? Well, beyond meeting your legal obligations, it's simply the right thing to do. Imagine being accused of wrongdoing and never given the chance to explain yourself. It wouldn't feel fair, and it isn't. Procedural fairness isn't just about compliance, it fosters trust, transparency, and credibility in your workplace. Importantly, procedural fairness also plays a key role in defending legal claims, particularly unfair dismissal. Let's now turn to unfair dismissal protections. An employee who believes they were dismissed in a way that was harsh, unjust, or unreasonable may lodge a claim with the Fair Work Commission. This applies to full-time, part-time, or and regular casual employees who meet the minimum employment period, 6 months for larger businesses or 12 months for smaller businesses, and who are either award covered, covered by an enterprise agreement, or earn under the high income threshold. When assessing these claims, the Commission doesn't just look at the reason for dismissal. They closely examine the process. Was the employee informed of the allegations? Were they given an opportunity to respond? Was the decision based on clear evidence? And did the process involve impartial decision making? If procedural fairness wasn't followed, even a legitimate reason for termination may not be enough to protect the business from liability. That's why a fair process is just as important as a fair reason. The second legal risk to consider is general protections. These provisions protect employees from adverse action, like dismissal, demotion, or discrimination, because they've exercised a workplace right. This could include making a complaint, requesting leave, or participating in lawful union activity. The risk here often arises when disciplinary action follows soon after an employee exercises one of these rights. Even if misconduct is genuine, the timing can raise questions and lead to a claim, particularly if the employer hasn't properly documented the rationale for the action. So, in summary, addressing misconduct is not just about taking corrective action, it's about managing risk, maintaining compliance with the Fair Work Act, and most importantly, upholding a fair, respectful workplace culture. The combination of operational awareness, procedural fairness, and legal compliance is what ultimately protects your business and your people.
Thank you, Rishi, for going through that. Now we're going to go through a few more topics looking at the early signs and red flags, I guess, things to look out for with misconduct. So the reality is that not every issue will start as a major incident worthy of immediate formal action. Often there are early warning signs or patterns of behavior that, if addressed early, can prevent a situation from escalating into something more serious, potentially saving an employee and, costly legal proceedings that might happen. That proactive management part involves identifying and intervening when issues are still minor and staying attuned to changes in the workplace environment. These type of, I guess, uncomfortable conversations that can happen earlier on, might save you, a formal action later on. So even though it might be hard in the moment, to bring it up or have those discussions with the employee, it could end up saving you, a lengthy formal disciplinary process that, no one really wants to go through. Um, so a couple of the red flags to look out for, and we've got them on the slide, are looking at the first one. So changes in the employee's attitude and their engagement levels. Are they, quite withdrawn? They're not really reaching out as much. Is their productivity dropping? Are they seeming like frustrated or angry at, little things? Is that popping up? Conflict and tension within a team. So are they, like I said, is that frustration there? Are they disagreeing? Is that communication breaking down? They're refusing to like do things that they usually do. Are they refusing to collaborate? Um, the other ones are up there, but just quickly going over them. The minor policy breaches, lateness, just completely disregarding what you're saying. Um, Disrespectful, inappropriate behavior that starts, subtly, like eye rolling, sarcastic comments, and that lack of accountability or unwillingness to follow directions, blaming others for mistakes, constantly challenging you and, challenging instructions or challenging aspects of their role that they've kind of always done, that are unreasonable, obviously. These are those red flags that there may be something deeper going on. And like I mentioned, the key here is to stay alert and address these type of issues early. So, like I said as well, when we do have managers and we do have clients that avoid those conversations because they might be feeling uncomfortable or they just don't want to, they don't think it's worth it. These small issues become big issues very, very quickly, and they're much harder to correct and are likely to lead to formal disciplinary action the longer that you let them go on. Perfect. So now we'll look at when to kind of informal action versus formal action. So once you've identified that issue, your immediate decision and what you would need to consider is to determine the appropriate level of intervention. This will be guided by things like the severity of the incident and the history of that personal employee's behavior. So, as I kind of went over previously, informal action is kind of related to misconduct, and it's generally suitable for first time, non-deliberate issues. How you would kind of deal with this is it could be a private coaching style discussion aimed at quickly realigning expectations, clarifying policies, and explaining the impact of the behavior. The goal here is obviously resolution and improvement without a formal process or a formal outcome. Um, Formal action, on the other hand, is required when the behavior is repeated, deliberate, or serious in nature. So, looking back at that serious misconduct definition, or when previous informal attempts, they just aren't working, and the employee continues to disregard, obviously, what you're saying. They're continuously being late. They have no reasonable excuse. Then you're going to start looking into a structured investigation, potentially issuing written warnings, and ultimately also looking at maybe looking at termination as well. Regardless of your choice, it's really, really critical to document any of these discussions that you're having. So, what I always advise clients when they're calling up is even if you're having a really informal chat with an employee about them not arriving on time or always returning back late from their lunch break or something like that, even from the get-go, you should be, really resetting those expectations, nipping it in the bud early, and sending an email. I always recommend our clients just to send a quick little email saying, hey, recapping your discussion, resetting those expectations. And if it's coming to a point where it's happened multiple times, I'd also be outlining that further breaches or further like failure to follow XYZ process can relate or can mean that it can proceed to potential further disciplinary action up to including termination. So I would be like setting those expectations right from the get-go so you don't have any miscommunication about what the employee should be doing moving forward. Which kind of leads into our next topic, condonation. This concept, majority of our clients have not heard of, and it's something that when we do bring it up, they are kind of like, "Oh, I didn't know what that was. Now I know." So taking that action, whether formal or informal, is really important because if you don't do anything at all, you're essentially condoning an employee's behavior and misconduct, which makes it harder to treat and or address later on. So condonation occurs when an employee becomes aware of misconduct. They know it's happening, but they fail to act or follow. They fail to act or follow up with behavior, and it continues to happen over a period of time. And then, if you later kind of attempt to discipline or terminate the employee for that same previously ignored issue, like such as give them a formal warning or terminate them, you are going to be posing quite a significant risk because you initially haven't done that behavior, which could potentially mean that the warning that you provided is invalid or the termination will be seen as harsh. The Fair Work Commission may determine, like I said, that an employer has effectively condoned or accepted that behavior by failing to address it promptly and consistently. So, as an example, if you've got an employee who is consistently late, they've been late for potentially the past two days out of the week for the past 6 months, substantial period, and you haven't done anything about it, and you haven't addressed it with the employee, and then you suddenly attempt to initiate a formal disciplinary action purely out of rising frustration that the employee, has been late for the past 6 months, twice a week for the past 6 months. Obviously, you're going to be in a position where you're quite emotional. You're really, really frustrated. You're like, damn, this has been going on for 6 months. I need to do something about it right now so that it stops happening. This risks you being viewed as condonation. You've permitted that behavior through your inaction. To remove that risk, our first recommended step, and sometimes, it's going to be hard because you're going to be frustrated, you're going to want to take a harsh action, is to immediately halt any formal disciplinary processes and instead hold a structured informal discussion. This conversation, as I mentioned previously, should clearly reset those expectations regarding attendance and punctuality, explain that, the impact of you being late on these days impacts XYZ operationally. And moving forward, you need to ensure that, if you are going to be late, it's not just because you slept in or it's not just because of whatever reason, because it has that like significant operational impact. And you also would need to outline that further instances of this misconduct could lead to formal action if there's no reasonable excuse. Obviously, we would need to take into consider if, say, they were late because of a personal carer's reason or, something to do with family domestic violence, something along those lines, we would need to consider it. But if it's because their alarm didn't go off or, they didn't leave early enough or something along those lines, unfortunately, that's just not going to cut it. And having those conversations and sending that email after that initial chat is really going to set that clean starting point for the employee. And they're going to clearly understand that in future, if that behavior continues to happen, could lead to formal action. And understanding this is why it's so important to understand, I guess, the timely action, which naturally will lead into the next stage of managing misconduct. And it's knowing when an issue has escalated to the point where a formal investigation is required, which Rishi will take you through.
Thanks, Georgia. Now, when dealing with alleged allegations of serious misconduct, one of the first decisions you need to make is whether a formal investigation is actually required. An investigation is not always necessary. If you already have clear and sufficient evidence, for example, written communication that shows the conduct occurred, or if the employee admits to the allegation in full, you may be able to proceed straight to the disciplinary process without further fact-finding. However, where the facts are unclear, in dispute, or the alleged behavior is potentially serious, a structured investigation becomes essential to reaching a procedurally fair outcome. Investigations are typically required when more information is needed to determine whether the allegation can be substantiated. This includes matters such as bullying, discrimination, sexual harassment, or other breaches of policy and behavioral standards. They are also common following workplace health and safety incidents, particularly where an accident or injury has occurred, and are critical when dealing with allegations involving theft, fraud, physical violence, or other forms of serious misconduct. Where criminal conduct may be involved, it's important to manage your internal process carefully to avoid interfering with any external law enforcement matters. So, why do we need to do an investigation? What's the purpose of doing that? At its core, a workplace investigation is about gathering evidence. It helps the business determine on the balance of probabilities whether the alleged misconduct occurred. The standard of proof is not beyond reasonable doubt, like in a criminal case, but whether it's more likely than not the conduct took place. A fair and objective investigation helps eliminate bias, supports a sound disciplinary decision, and most importantly, reinforces procedural fairness, a core requirement under the Fair Work Act when managing potential dismissal. Now, let's look at who might be involved in the investigation process. Firstly, the complainant is the person raising the grievance or allegation. Second, the respondent is the person accused of engaging in misconduct. Now, you may also have witnesses who are interviewed to provide factual information. Then there's the investigator, who's responsible for gathering all relevant information. The investigation must be impartial. Investigator, sorry, must be impartial, experienced, and unbiased. They could be from your internal HR team, or you may choose to engage an external investigator, particularly where the issues are complex, sensitive, or involving senior staff. Finally, there is the decision maker. This is the person who reviews the investigation report and decides what, if any, disciplinary action should follow. Wherever possible, the investigator and the decision maker should be two separate people. The separation reinforces objectivity and fairness in the process. For smaller organizations, if a full separation isn't feasible, you may need to implement safeguards such as bringing in an external advisor or a HR consultant, should there be a need to manage actual or perceived conflicts of interest. Now, let's talk about why this process matters. Investigations play a critical role in helping businesses defend against legal claims, particularly unfair dismissal claims under the Fair Work Act. In 2023, the median settlement cost for such claims was around 5 to 7 weeks of pay, though some extended much further. If a claim goes to a hearing and the employee succeeds in the claim, the Fair Work Commission can award compensation of up to half the employee's annual wage, capped at $91,000, $91,550 for the 25-26 financial year. These costs, along with legal fees and the impact on culture and morale, can be significant. However, where a business can demonstrate that it conducted a procedurally fair investigation, its position in defending a claim is greatly strengthened. Procedural fairness isn't just best practice, it's expected. This means giving employees a chance to respond to allegations, informing them of the process, and considering their version of events genuinely and without bias. Finally, one important point. If an investigation is underway, it may be appropriate to suspend the respondent on full pay. Georgia will take you through when a suspension might be needed and how to do it in a way that is compliant.
Thank you for that, Rishi. So, when a situation escalates beyond informal management and does require that formal investigation into serious misconduct, your interactions with the employee will shift significantly. We're now entering a phase where procedural fairness is paramount to reduce any risks to claim against the business. We're going to focus on three critical elements when you're kind of at that phase of the misconduct or investigation process, which is the suspension, communication, and support to the employees involved. So that decision to temporarily remove an employee from the workplace through suspension is quite a serious step that you can take. And it's usually what you would look at doing when you are kind of feeling really confident that the action that's happened meets that definition of serious misconduct, as mentioned before. It's not a penalty. It is a procedural measure, and it can only be taken where it's reasonable and necessary in the circumstances of the incident that's happened. It does, I guess the authority for suspension stems from the common law right of an employer to issue lawful and reasonable directions, which is supported by long-standing principles of employment law and federal court case law, such as the ruling in Avena versus Railway and Transport Health Fund Ltd. This right exists even if a suspension clause is not explicitly written into the contract, provided the direction is reasonable. So when should you suspend an employee? And maybe on the cards if their continued presence in the workplace could potentially create issues to the conduct of your workplace investigation. And some of those examples include workplace safety. So if the alleged misconduct relates to violence, aggression, harassment, or poses a clear physical danger to themselves or other staff, if you are aware that they're making threats against other people, things like that are popping out, this is directly linked to that employer's non-negotiable obligation under the work health and safety legislation to maintain a safe work environment. And if you as an employer you're aware that these kind of issues are happening, you're aware that they're making threats to other people in the workplace, but you're not taking that seriously, you potentially are at risk of breaching your obligations under the Work Health and Safety Act, to maintain that safe work environment. The other reason that you would look at suspending employee is if it's going to impact the integrity of the investigation. So, if there's a legitimate and factual basis for concern that the employee potentially might tamper with any evidence, destroy documents, is going to intimidate, pressure, or influence any witnesses involved in the inquiry, this protects the evidentiary foundation of the disciplinary process by removing that person from the workplace. And business risk, in specific cases where the allegations relate to severe financial mismanagement, theft, or misuse of highly sensitive information that could cause immediate and reversible damage to the business, its clients, or the reputation, the risk must be obviously active and pressing and relating to that, then that would be a reasonable, reason to suspend that employee. A key requirement, suspensions must be fully paid, especially obviously if you're a permanent employee. If you're a casual, it doesn't really apply, unless your award agreement explicitly allows for unpaid suspensions. This is very specific and a rare circumstance. And suspending an employee without pay when it's not explicitly permitted is a high risk action, and it can relate or can result in underpayment claims being made against the business of the employee when you're already going through quite a highly stressful process. Adding another layer of an underpayment claim to the mix is not ideal. Um, so beyond the question of suspension, the way that you kind of communicate with and support the employee during the entire formal disciplinary process is paramount for achieving a sound outcome. Clear documentation is obviously your best defense when it comes to this. So communication protocols, written and formal. Providing that written communication is obviously fundamental to procedural fairness, and a key consideration when ensuring a dismissal is not deemed harsh, unjust, or unreasonable. So making sure that your written allegations are detailed when you provide them to the employee. You must be fully informing the employee precisely of the allegations, not just saying like, you've behaved badly, or we're making this allegation of misconduct against you for what you did. That's too vague. It needs to be specific, including the date, the time, around about time, where, how it occurred, if it breached a policy, what policy did it breach, or if it breached a law, what law did it breach? And this must obviously be provided in writing. that opportunity to respond. So, as kind of Rishi went over, given that reasonable opportunity to respond to the allegations before any final disciplinary decision is made, the Fair Work Commission will frequently find a dismissal to be unfair if the employee was not generally given a chance to explain their conduct. Um, and the last one is confidentiality and privacy. All managers and investigators must maintain that strict confidentiality regarding the details of the investigation and employees. So, what I would be doing if you're going to be going into a misconduct scenario or an investigation process or anything like that is saying at the start of the meeting, just have to obviously say that this meeting is completely confidential, and if you like fail, it needs to be kept with everyone in this room. You can't repeat it to anybody else, and failure to do so can potentially lead to further disciplinary action, formal warnings or even termination in some instances if it's really, really severe. Um, and then lastly, we've got providing support to the employees. So obviously, a disciplinary process, it's quite a stressful time. Like if they're facing some very serious allegations that they've maybe engaged in, it's going to be really, really important that you still mitigate that stress that can come from this scenario. So if you do have services like EAP, reminding them to speak up and like chat to someone about it if they want to, making yourself or any other managers available in the workplace to chat to them if they're feeling like quite emotionally stressed. Um, and these kind of things would definitely recommend when you're going through this process, just to show that the employee is being supported and that you're not just disregarding them because of obviously what they've done. Um, and now we're kind of going to go into the disciplinary outcomes that can happen, and Rishi will take you through that.
Perfect. Now, once the investigation is complete and you have met with the employee to give them an opportunity to respond to the allegations, the next step is to make a clear finding on each allegation. This involves assessing the evidence and determining whether the alleged misconduct is substantiated, unsubstantiated, or partly substantiated. Only after you have made these findings should you move on to determine and communicate the appropriate disciplinary outcome. Separating the fact-finding stage from the decision-making stage is critical, not just for legal compliance under the Fair Work Act, but also for ensuring fairness, transparency, and consistency in your workplace. Let's break the stage down into three key parts: weighing the evidence, deciding on an appropriate outcome, and communicating the decision lawfully and respectfully. Weighing the evidence. When you're weighing the evidence in a disciplinary process, the goal is to work out what most likely happened based on the information you've gathered. In workplace matters, we use to balance the probabilities, meaning you're asking yourself, is it more likely than not that the alleged conduct occurred? To get there, you need to approach the evidence in a structured and fair way. That starts with gathering all the relevant information, documents, emails, policies, screenshots, timelines, and anything else that helps build the picture. If there are witnesses, speak with them or ask for written statements, especially if they directly observed or were involved in the situation. As you review the evidence, your job is to stay impartial. Look at the consistency between different accounts, whether the information is supported by objective facts, and the overall credibility of each source. At this stage, you're not deciding on outcomes, you're simply determining what did or didn't occur. A fair process is essential. The employee must understand the allegations and have a genuine opportunity to respond before you make any findings. The person assessing the evidence should be unbiased, following internal policies, and make a decision within a reasonable time frame. Number two, deciding on an appropriate disciplinary outcome. Once the evidence has been considered, you'll then need to decide on a proportionate outcome. The range of possible disciplinary actions may include no formal action where the allegation isn't substantiated or further education is more appropriate. Verbal warning, generally used for minor or first-time misconduct. Formal written warning, where the conduct is more serious or the employee has already been warned verbally. First and final warning, in cases of serious misconduct, where further issues may lead to termination. And finally, termination of employment, generally appropriate where the misconduct is very serious or there's a repeated history of issues that the employee has failed to rectify. There's no law requiring a specific number of warnings before dismissal, nor any fixed period that a warning must remain valid. Instead, you must take into account the seriousness of the conduct, the employee's history and tenure, whether the employee was given a reasonable chance to improve, and whether your organization has followed a fair and consistent approach. If dismissal is being considered, it's crucial to ensure that the decision is justifiable and procedurally fair, and that you've documented the process thoroughly. Now, finally, communicating the outcome. Once a decision is made, it must be communicated to the employee both in writing and, where appropriate, in a further face-to-face meeting. If the employee is to remain employed, the letter should confirm the findings from the disciplinary process, the specific warning being issued, what the employee is expected to do moving forward, and that further misconduct may result in more serious disciplinary action, up to and including termination. If termination is the outcome, the letter should clearly state the reasons for the decision, the effective date of termination, and final pay entitlements as required under the National Employment Standards. It's best practice to deliver this information in person or via video call where an in-person meeting isn't possible, especially in the case of termination. This gives the employee an opportunity to ask questions and help ensures dignity and clarity are maintained throughout. You may also need to consider longer term operational or organizational impacts. For instance, the outcome of an investigation might require change in team structures, training needs, or broader cultural improvements. In some cases, support should be offered to other staff members involved in the process to safeguard well-being and rebuild trust. Finally, be aware that some outcomes, particularly dismissals, can lead to dissent or dispute. To protect your business and minimize disruption, it's important to have a clear communication strategy, comprehensive documentation, and a transparent process. In practice, this might include preparing managers with clear talking points for meetings, keeping accurate and detailed records of all discussions and decisions, communicating process timelines to staff without breaching confidentiality. To wrap up, always remember that procedural fairness must be present throughout every stage, from the investigation through to the final outcome. A disciplinary process that lacks fairness, even if the outcome seems justified, will rarely withstand legal scrutiny and may significantly harm workplace culture.
Thanks, Rishi. Now we're going to our next part, which is post-misconduct follow-up and what happens after serious incidents kind of happened and how to regain that trust throughout the workplace. Obviously, your work is not done when you've finished that investigation and the necessarily disciplinary action is taken. The final crucial phase is that post-misconduct follow-up. This is where you're healing the organizational culture, restoring team morale, and ensuring that the business learns from the incident. It should be treated as a organizational case study when you do have a serious incident that pops up. You will need to review your entire processes, not just to confirm that fairness of the outcome, but to identify any weaknesses in your system. Asking yourself these key questions. Was your policy clear? Did the breach occur because the policy was potentially ambiguous, outdated, or difficult to follow? If that is the case, immediately initiate a policy update and eliminating any of that confusion. Was the training effective? Did the employee who committed the misconduct understand the standard they were violating? If not, again, that training method will need to be updated. Did the early warning system fail? Did you have managers that were unable to recognize the early signs of misconduct as we kind of went through earlier, those red flags? If that issue kind of stems from 0 to 60, there was probably likely a management failure in the middle that would need to be addressing through potentially training. You should be really using these incidents to strengthen your internal documents and systems. And this would demonstrate a commitment to that continuous improvement, and it does strengthen your defense that if it does pop up in the future, you're kind of going to know where it went wrong and where you need to step in. Sometimes if these incidents can happen, it can potentially leave the team feeling a little bit anxious, maybe uncertain, maybe there's a lot of gossip going around. And it kind of makes it a little bit awkward and you don't know like if you should be addressing, the big elephant in the room. We would recommend to communicate with your employees. What you should be communicating is focusing on the process, not the person. Obviously, due to privacy legislation, you would need to protect the employer or the previous employee, their rights. So you're generally not in a position to share specific details about the allegations, the investigation findings, or the disciplinary outcomes applied. Obviously, if they're no longer with the business, you can kind of say that in a roundabout way, but specifically outlining exactly what was said, what was happened, who it was said to, it's just not really necessary. And then we should be looking at re-communicating the standards around obviously everything that's happened. So outlining that workplace standards, they're non-negotiable, there was action taken. A typical message you could say was, obviously a serious incident's happened regarding the breach of whatever policy. This has been investigated and appropriately dealt with, in line with our kind of company policies and procedures. And I would also be emphasizing that the business is committed to maintaining a respectful and safe environment for everyone, and that closes the loop, and prevents speculation from eroding trust. And then after kind of that's also happened, we would also recommend potentially doing a wider refresher on more targeted training. Don't like, waste that opportunity. Do you know what I mean? If it's involved bullying or harassment, consider scheduling mandatory refresher training on your equal employment opportunity policies and respect at work policies, for the entire affected team or even the entire organization. If it lacks accountability, managers might require training on performance coaching or having those like difficult conversations. It targeted training like this not only upskills your workforce, but it also provides that additional layer of evidence that you as the employer take your obligations very seriously, reinforcing a culture of compliance starting at the top all the way down and throughout. And it also can potentially outline the psychological safety and the team morale. Employers might be wondering if they're safe in the workplace, if their complaints will be handled fairly, or if the manager responsible for the original oversight is a competent manager. You don't want your employees to start thinking that your managers aren't capable of supporting them through the workplace. And particularly after this, your managers will be needing to look out for everything and be quite highly visible. Active listening, not listening out for like gossip and things like that, but more so listening out for how your staff are feeling. Are they feeling okay about everything? Do they need to chat to anyone? And this will rebuild that psychological safety, rebuild that trust, make them feel that they're confident that they're going to be listened and heard to in times when it's needed. And I guess kind of the final step will be focusing on the future. So shift that team's focus to the incident that's happened, back to the core goals and what they're trying to achieve at the business. Start celebrating those small wins again, celebrating those collective achievements, foster that positive team dynamic, and to just restore that sense of, I guess, normalcy, and confidence in leadership. By treating these post misconduct phases as a vital opportunity for cultural reinforcement and growth within the business, you do minimize that long-term damage that can be caused by a serious incident happening.
Okay, now let's look at a real life case that demonstrates why a fair, transparent, and structured disciplinary process is essential. The case of Kevin Emery versus City of Stirling went before the Fair Work Commission. It showed that even when an employer proves genuine misconduct, a dismissal can still be ruled unfair if the disciplinary process is not handled properly. Bit of background on the case. Mr. Emery worked as a beach inspector with the City of Stirling. During an internal review of the fleet, the city discovered that several beach patrol vehicles had been altered so that the air conditioning ran automatically when the engine started. These changes had not been approved, and City believed they had caused substantial mechanical damage and significant financial cost to repair. The Commission ultimately accepted that the modifications were made without permission. In other words, the city did have a valid reason for dismissal. Despite this, the dismissal was still found to be unfair because key elements of procedural fairness were missing. Now, where the process broke down, the Fair Work Commission concluded that the way the disciplinary process was handled fell short of the standards required. The most significant failings related to the clarity of the allegations, the information provided to the employee, and the opportunity to respond. Number one, the allegation lacked detail. The letter inviting Mr. Emery to the meeting simply stated that he had altered vehicles and caused damage. It did not set out what specific alterations were made, which vehicles were involved, when the conduct occurred, what type of damage the city believed had occurred, what costs were said to have resulted. Because the allegations were so broad, Mr. Emery was not properly informed of the case he needed to answer. Number two, termination was not flagged as a potential outcome. The invitation to the meeting did not alert Mr. Emery that his job was at risk. The Commission found that without being told dismissal was being contemplated, he could not fully understand the seriousness of the process or adequately prepare for the meeting. Number three, he did not have a meaningful chance to respond. The combination of vague allegations, undisclosed details about the alleged damage, and no warning of possible dismissal meant that Mr. Emery was not given given an opportunity to influence this decision. This breached the requirements in the Fair Work Act, which require employers to give clear notice of the reason and allow a proper opportunity to respond. The outcome was that the dismissal, although based on valid misconduct, was still categorized as harsh, unjust, or unreasonable. Now, key lessons for employers. This case illustrates several practical points for employers when managing misconduct. Number one, a valid reason alone does not guarantee a fair dismissal. Number two, allegations must be specific and complete. Number three, employees must be told if dismissal is being considered. And number four, the opportunity to respond must be real, not superficial. Why this case matters? Emery reinforces that procedural fairness is not a box-ticking exercise. It is a statutory requirement grounded in the Fair Work Act. Employers who take the time to carefully draft allegations, issue clear meeting invitations, avoid assumptions, and genuinely consider an employee's response are significantly better positioned to defend their decisions. A fair process protects both the organization and the integrity of the outcome. When employers get the procedure right, they minimize the risk of an otherwise justifiable dismissal being overturned due to avoidable errors, sorry.
Thank you for that case, Rishi. That was really interesting and it gives a good, I guess, oversight into why it's important. Um, we are done with all our content today. So thank you so much, everyone, for joining. We are going to jump into some Q&A, but before you do jump into that Q&A, it is worth asking yourself, I guess, if misconduct happened tomorrow, would your business have the right tools and support behind you? Obviously, today we've talked about why the correct processes matter. Documentation, investigations, procedural fairness, and communication. When these steps are handled the right way, they protect both your business and your people. And they're far easier to manage when you have all the right systems and tools and guidance from the start. So, if you don't currently use Employment Hero, we do offer an employment evaluation, which is a tailored conversation with one of our sales specialists. It's about understanding your current HR needs, what processes you already have in place, and whether our platform and advisory support can help your business manage these situations with confidence. If you are already Employment Hero customer, hello, but you do not have an advisory service added on, this is a chance to explore whether access to our advisors like myself, Rishi, and Candy, who's in the comments, as an additional add-on to your current subscription. And we can help your team manage more complex issues and reduce that risk of costly mistakes. Just to be very clear, these sessions aren't advice or training sessions. They're designed to help assess whether these solutions are right fit for your workplace. We've got a poll on the screen now. And if you would like an employment specialist to contact you, simply choose the option that applies to you and someone will be in touch. So yeah, thank you so much. We will jump into some questions. Rish, did you want to go first?
Yeah, I did see one there. Jane asked, "What do I do if my employee doesn't come to their disciplinary meeting?" Ah, okay. This. is definitely a more tricky one. In some cases, the employee's absence could be seen as their response, but it's always a good idea to try and contact the employee to ask why they didn't attend. Then, based on their response, if they have a genuine reason for missing the meeting or not, you can determine whether the absence will be taken as their response or whether rescheduling the meeting would be appropriate. That's another case in which we highly, highly recommend seeking professional advice and definitely giving us a call.
Thanks, Rich. I've just found one. Theo has asked, what do I do if the conduct isn't severe enough to dismiss my employee? So we kind of touched on this earlier on, but this will obviously depend on what's happened. So like what's the context and what's the facts of the situation. If it's something kind of minor and it doesn't warrant a formal investigation or disciplinary process, like I said before, having those informal discussions with the employee, even a verbal warning. I would always, if it's something not too serious, I would probably always start out with just having a recap discussion saying, hey, like we've noticed that you're late. And it's been going on for like, however, 4 weeks, 5 weeks. Is there anything else going on right now? What's stopping you from being able to attend work on time? Asking those questions and seeing if there maybe is something else going on. Because obviously you don't know if you don't ask. So with kind of lesser serious matters, that's kind of where I would be starting, asking those questions. And then obviously moving into resetting those expectations, still happening again. You could even play it real safe, go for another informal chat and give them a verbal warning. And then obviously, if you are going into the more serious matters, your outcomes could be things like a first written warning, first and final written warning, pending how serious it is. And then also like summary dismissal. But that obviously is only something that should be happen if it's very, very extreme. We definitely recommend seeking professional advice if your employee's behavior could be seen as serious misconduct, because what you might think is serious misconduct might not be. So yeah, definitely get in touch if you need. Um, that was kind of all we had time for today. We're right on the minute, so great work to us for keeping in time. But thank you so much for attending today. And like I said, we'll be answering those questions, any ones we didn't get to later on, and hope you have a lovely day.